Welcome everyone to today's discussion about the end of Title 42 and solutions at the border. I'll be today's moderator, and let me start by introducing myself and my fellow panelists. Then I'll review the logistics for the webinar and make a few opening comments. My name is Angela Kelly, and I'm the Chief Advisor to both the Council and the American Immigration Lawyers Association. Before joining the Council in AILA, I was a Senior Immigration Counselor to Secretary Mayorkas, and before that, I oversaw the immigration work of the Biden-Harris transition team. For those of you who are unfamiliar with the Council, we are a nonprofit organization who believes that the U.S. immigration system should be fair, just, and welcoming. We pursue this objective through a multi-pronged approach, including impact litigation, advocacy, research, transparency efforts, narrative change, and expanding access to counsel for immigrants. I almost forgot to make this important plug. Going back to the panelists. Joining me is Aaron Reichlin-Melnick, the Council's policy director. He is an authority on immigration law and policy. He has a prolific presence on Twitter and extensive experience representing immigrants. Next speaking will be Alex Miller. Alex is based in Tucson. She is a director of the Council's Immigrant Justice Campaign. She came to the Council with extensive experience in border and asylum matters, having worked at the Florence Immigrant and Refugee Project and at the International Rescue Committee. Also joining us is Jorge Lowry, the Council's Managing Director of Programs and Strategy. Like his colleagues, he is an authority on immigration law and policy, and he comes with extensive Hill experience. Now for housekeeping. Interest in this webinar has been record-breaking. And so if someone you know, someone in your organization wasn't able to join, please tell them to join us on Facebook Live. Today's webinar will also be recorded, and we will email that recording to everyone who has registered for it. Our audience will be muted throughout the webinar. If you have a question for our speakers, please put your question in the Q&A box on your screen. We'll do our best to answer as many of your questions as possible. Okay, just to do a little context setting then before we turn to our speakers. Those of us in the immigration field are used to an ever-changing landscape of law and policy. It's not an exaggeration to say, however, that the policy changes at the southern border, particularly how they impact asylum seekers, has reached an unprecedented level of sweeping change. The multiple proposals unveiled by the Biden administration as recently as an hour ago in a press conference with Secretary Mayorkas is a clear recognition that the end of Title 42 authority that has allowed the expulsion of more than 3 million migrants represents a huge test for border management and processing asylum seekers. The administration has reached far and wide in expanding legal channels for people seeking entry, something that we support. However, at the same time, through effectively putting forward a rule, a transit ban, we expect that that will have devastating impact on vulnerable migrants, especially those trying to cross between ports of entry. In today's conversation, we're going to try to do two things. One is to give you as clear a picture as possible of the shifting policy landscape and how that might look for people seeking asylum at the border. But the other is to take a deep breath and to look beyond today. We know that the push factors that are driving the current surge in migration are likely to accelerate, and forced migration from throughout the hemisphere in the coming decades is only going to grow. And that's not just a challenge of the Biden administration. Spontaneous and irregular migration to the US has challenged every president since the time of Reagan. So there's no argument that we need to improve our ability to decide who is admitted to the US, protect those who are fleeing persecution and violence, and do it in a way that inspires confidence that the situation is being handled competently, efficiently, and fairly. We need a plan that takes both short-term steps to build up to a workable asylum system in the long term. It's a plan that needs to, in addition to managing asylum processing effectively, build towards a regional strategy that mitigates migrant and refugee movement to the border with widened legal channels and manages arrivals from the border into communities throughout the US who receive them and welcome them. The Council has just released for action a blueprint that have taken together and implemented fully over time would put in place a system that protects our borders, protects refugees, and protects the US moral standing as a safe haven and a global leader in human rights. So we're going to try to have both these conversations, and I'm going to turn it first to you, Aaron, to kick us off.
Thank you, Angie, and thank you to all who have joined us today for this really important webinar. Over the last 3 years, the US border has been largely shut to tens of thousands of asylum seekers. Thanks to Title 42, the Department of Homeland Security has carried out over 2.8 million expulsions in total in a 3-year period, nearly all of which have involved sending migrants back to Mexico. And not surprisingly, when people travel thousands of miles to get to the US-Mexico border, attempting to seek safety here, once they've been expelled back to Mexico, they have ended up stranded in Mexican border towns in states of danger and trying to figure out what their next steps are. Given that reality, there is a significant number of migrants who have been waiting in Mexico for the end of a policy that all have known had to end eventually. Title 42 was a public health rule put in place in response to the COVID-19 pandemic. And as of tomorrow, all federal COVID-19 national emergencies will be terminated, and indeed, nearly all COVID-19 related prohibitions and policies across the country have been ended. So what we're seeing right now is the inevitable result of a policy which has left vulnerable people stranded in dangerous locations and waiting for a chance to seek safety. That's why we are already seeing a significant increase in migrants who have been coming to the US-Mexico border and crossing, attempting to seek safety either today when Title 42 remains in place and under the hope that they might not be expelled, or before the Biden administration's new policies go into effect. We know from previous instances like this that smugglers and other vehicles, people who are vehicles of misinformation, often use any change in border policy, positive or negative, to tell people now is the time to cross. And so it's not surprising that we are seeing a significant increase in the number of migrants crossing the border right now. However, we do expect that once this backlog of people who have been forced back into these dangerous conditions in Mexico sort of is reduced, the numbers are going to drop down to much more manageable, normal levels. However, as Angie said, what has changed in the last few years is the scale of migration throughout the Western Hemisphere. With 4 failed states in the hemisphere alone, and people forced to leave due to climate change, violence, displacement, political repression, and the whims of transnational criminal organizations, it's not a surprise that people still view the United States as a place of safety and freedom and believe that their best chances for a better life are here in the country. The Biden administration has been responding to this through a wide variety of measures, which they really adopted in so-called carrot and stick approach. What this approach says, and now the reality is that this stick is in many ways much bigger than the carrot, and the Biden administration has done this in a number of ways. Back in October, they reached a deal with Mexico, allowing them to expel Venezuelans to Mexico under Title 42, a deal which was expanded in January to include Cubans, Nicaraguans, and Haitians. And it's been reported, and Secretary Mayorkas has confirmed, that Mexico, even after Title 42 has expired, will continue to permit the United States to send, at the very least, Venezuelans, Cubans, Nicaraguans, and Haitians back to Mexico, even though they are not from Mexico. In exchange, and at the same time, the Biden administration has also proposed and is now finalizing, starting tomorrow, a new restriction on asylum for individuals who transit through a third country prior to arriving in the United States and who do not apply for asylum and get denied in that third country. This ban, which largely mirrors the Trump administration's 2019 asylum transit ban, is set to go into effect for any person who crosses the border after tomorrow. And I know we're going to talk more about that ban next, so I'm not going to get into too much detail now. At the same time, however, it is important to note that the Biden administration is expanding alternate legal pathways for people to seek protection, and it's doing so through a number of different ways. First, the Biden administration has created targeted parole programs that benefit specific nationalities, with the goal of giving people an alternative to coming to the United States that doesn't require them to make the dangerous and arduous 1,000-mile-long journey to our borders. Right now, there are parole programs for Cubans, Haitians, Nicaraguans, and Venezuelans that allow up to 30,000 individuals of those countries each month who have a sponsor in the United States to come to the United States through temporary humanitarian parole for up to 2 years. Crucially, this pathway is only available to those individuals who have passports, who have sponsors in the United States, and who can afford to buy a plane ticket to this country. So it is not a pathway that is eligible for all migrants. And if you don't come from one of those 4 countries, then there is no similar option for you. However, in an announcement last week, the Biden administration said that it will be expanding and creating new pathways for Hondurans, Guatemalans, and Salvadorans as part of family reunification parole programs. Right now, we haven't seen any clear details on these programs, so we don't know whether they look like the parole programs that are eligible, that Cubans, Nicaraguans, Haitians, and Venezuelans are eligible for, or whether they mirror much smaller scale family reunification parole programs that the Obama administration created for Cubans and for Haitians in the past. The Cuban and Haitian family reunification parole programs were only available to people who had already had family members sponsoring them, lawful permanent residents sponsoring them in the United States, and required a complicated process that involved an invitation to apply for the program from the National Visa Center, as well as then an application process, which could take upwards of 1 to 2 years. So we don't know yet what form these Central American parole programs are going to look like, and we are expecting to hear more from the administration in the future. The administration has also said that it is going to create so-called regional processing centers in so far just Guatemala and Colombia, where migrants or any people who live in those areas would be able to go to these regional processing centers and determine whether or not they are eligible for any kind of status in the United States, whether it would be formal refugee processing or parole or even a visa. Again, these are things that were announced last week. We do not have any further details than that, and so we remain cautiously optimistic about the idea of this, but are concerned that they could possibly be used essentially to deter people from seeking asylum. And so we are keeping a close eye on these programs, but at this moment, we don't have much more information other than that the Biden administration has reached commitments to take more people through these alternate pathways. And then finally, the Biden administration has created a new process for seeking asylum at ports of entry. Today, more people are being accepted allowed to apply for asylum at ports of entry than under any previous administration. At its peak, the Obama administration processed roughly 20,000 people in October of 2016, the highest month ever for people processed at ports of entry. In December and March in 2022 and 2023, the Biden administration processed 30,000 people. So already we have seen a 50% increase in people processed through ports of entry under the Biden administration. And they have said that starting this week, they intend to expand the number of people allowed to access the asylum process at ports of entry from 750 a day now to up to 1,000 a day. But that supply is vastly outstripped by the demand. And the Biden administration has conditioned asylum under this new rule to being able to access the ports of entry. Earlier this week, the Biden administration announced that the process for seeking asylum at ports of entry through CBP-1 is going to require people to essentially win a lottery. They'll have to get an appointment through the CBP-1 app through the use of a random algorithm. In other words, they have to win a lottery. And that is a massive fundamental shift to how we have processed asylum seekers, and something that is deeply concerning, that your eligibility to seek asylum in this country would come down to your luck. With that, I think that really shows how the Biden administration is approaching this. They are emphasizing, and the Secretary Mayorkas emphasized in remarks earlier today, they are saying that they are going to be very harsh on any asylum seekers who come through ports of entry, but at the same time, they are saying, don't go between the ports of entry. If you come to the ports of entry or take advantage of one of our other alternate pathways, we're going to make this safer and easier for you. But for all of those people who are not able to take advantage of one of those pathways, that makes asylum further out of reach than it's been in a long time. And so with that, I'm going to turn it over to our next speaker.
Thank you. Our next speaker is Alex Miller with the Immigrant Justice Campaign. Alex, your perspective from the border, tell us.
Hi, thanks, Angie, and thank you, Erin, for setting the scene in that way. You know, I think it's really important to start with an acknowledgement that the end of Title 42 is a really good thing. For the past 3 years, asylum seekers have not been able to access asylum the way that they historically have. But 3 years of border closure and broader global migration trends make this a really challenging moment. In response to the challenges that the end of Title 42 presents, and this global context and strong political headwinds, the administration has now announced a suite of policies, including some of those potentially encouraging policies that Aaron outlined just now, but otherwise largely focused on enforcement and seeking to reduce the number of encounters we see at the border, in particular between ports of entry. The two main policies I will focus on are the circumvention of lawful pathways rule that was announced in final form this morning, and the announcement related to increasing reliance on expedited removal, specifically emphasizing using rapid, credible fear interviews in Customs Border Protection custody. So starting with the circumvention of lawful pathways rule, often referred to as the asylum transit ban. Well, we're still reviewing the final details since it just came out this morning. We had done a very careful review of the notice of proposed rulemaking and the initial draft of the rule, and it looks like not much has changed. The basic principles of this rule are reminiscent of a Trump-era policy that barred access to asylum for individuals who did not first seek asylum in transit. This rule restricts access to asylum, establishing a presumption of ineligibility for those who do not first seek asylum in transit unless they schedule their appointment to seek asylum using CBP-1, a smartphone app, or are otherwise exempted from the rule. This rule also will not apply to unaccompanied children or those who come to the United States under the pre-approved parole programs that Aaron was highlighting earlier. In theory, this rule should not apply if you couldn't use CBP-1 due to illiteracy, language barriers, or other technical issues that could prevent you from using the app. And in addition, the presumption of ineligibility for asylum could in theory be rebutted under exceptionally compelling circumstances, including acute medical emergencies, an extreme threat to life and safety, or meeting the definition of being a victim of a severe form of trafficking in persons. So why does this matter? How is this different from normal asylum? Federal law and international conventions have previously allowed for people arriving at the border to make a claim for asylum, regardless of whether you signed up for an appointment using a smartphone app or other means, and regardless of whether you applied for asylum in a country that you traveled through. More specifically, our domestic laws indicate that you should be able to seek asylum regardless of your manner of entry. And in that way, the rule itself, circumvention of lawful pathways, is a misnomer because it should be lawful to seek asylum regardless of your manner of entry. This is a really important shift in how asylum is treated here in the United States and could significantly restrict access to asylum for those who do not or are not able to use CBP-1 and did not seek asylum in transit. And importantly, ignores the fact that it may not always be safe or possible to seek asylum in transit countries, in particular when you look at the context of the dangers that migrants have faced in Mexico and the lack of infrastructure on the ground in many of these transit countries. At a functional level, it's impossible to predict exactly how this new asylum transit ban will play out in practice at the border. But the credible fear process will change. Instead of a purely fear-based assessment, an asylum officer will need to determine whether this rule should apply based on manner of entry, seeking asylum in a third country, and the restrictions and limitations to the application of the asylum rule. If that presumptive bar to ineligibility applies, individuals will then be subjected to a heightened reasonable fear standard in order to be able to seek protection in the United States. At a fundamental level, this means that they may be subject to removal based on factors that have nothing to do with their underlying claim for protection. Instead of streamlining the process, this rule could also make immigration proceedings more complicated, requiring significant efforts from U.S. Citizenship and Immigration Services, asylum officers who will be tasked with these screenings, and the immigration judges who are ultimately charged with their review. In addition, we have significant concerns about the use of this phone app, CBP-1. While Aaron highlighted some positive potential news about the restructure of how CBP-1 will be accessed and increases in the numbers of appointments, we know that the number of appointments will not meet the need and are still concerned about tech glitches and accessibility concerns. We also have concerns about what will happen at a practical level at ports of entry for individuals who do not have appointments, and concerns about migrants' abilities to defend themselves against this rebuttable presumption that they don't qualify for asylum, especially considering that the asylum transit ban will be nuanced in conjunction with this goal to increase reliance on expedited removal with rapid credible fear screenings occurring in Customs Border Protection custody. This has started as a pilot already, and our understanding is that use of rapid credible fear screenings in CBP custody is set to expand. In theory, taking a step back, expedited removal is a process to rapidly remove individuals who have no basis for protection in the United States and to expeditiously screen individuals who are making fear-based claims and may have valid asylum claims. It dates back to the 90s and has been increasingly used in recent history. We have historically had concerns about this process more broadly, in particular, due process, access to counsel, and transparency. These concerns are amplified when you consider their potential nexus with the asylum transit ban. As I said, the transit ban is complicated, and this means we're not talking about normal credible fear interviews. We're talking about rapid credible fear interviews happening in Customs Border Protection custody with limited access to counsel. We're talking about a system where asylum seekers will face a presumption that they do not qualify for asylum, or many asylum seekers. They will have the burden of demonstrating that the rule or the rebuttable presumption that they are not eligible for asylum should not apply to them, and then potentially need to demonstrate that they meet that higher reasonable fear standard, and likely alone, as migrants will be relegated to limited attorney access by phone. There are incredibly limited pro bono service providers, and they might not have access to counsel at critical points of the process. Further details on this are still unraveling, and so we'll need to keep a close eye on what's actually happening at the border. Our fear is that this will mean that individuals are erroneously ordered removed to their country of origin, or even that they may be removed to Mexico, since, as Aaron pointed out, Mexico announced it will accept individuals from Cuba, Haiti, Nicaragua, and Venezuela after the end of Title 42. We are extraordinarily fearful that removals will happen despite bona fide fear of persecution, and there will be precious few mechanisms for oversight or attorney intervention, especially to the extent credible fear interviews are happening in CBP custody, where attorneys and advocates have historically had little access. Happy to pass it on to my other colleagues.
Thank you so much, Alex. That was terrific. Jorge, we're going to turn to you now to give us your perspective, particularly from your experience on Capitol Hill.
Thanks, Angie, and good afternoon, everyone. Thank you for joining us today. I'm going to do my best to be brief so that we can leave as much time for your questions as possible at the end of the program. I'm going to focus on Congress and what is and is not happening to add some additional color to the current moment that we find ourselves in. So it goes without saying that this is a big week. This is a very big moment in historical terms when it comes to immigration issues in this country, and the policy changes that are implemented now and their impact will be studied and scrutinized for many years to come. There are a lot of changes that are currently in the works, as you heard from both of my colleagues a few minutes ago, but those changes that are being implemented today and in the coming days, whether or not we agree with them, are changes by the administration, the executive branch of the federal government. And while the executive branch has significant discretion and latitude to make changes to border management, there are some deep structural issues that are at play that have led us to the place that we find ourselves in today, when we have a system that is riddled with pitfalls, arbitrary outcomes, delays, one that is fundamentally ill-suited to meet the needs of the moment that we find ourselves in, which is the period of greatest displacement around the world in recorded history. These are fundamental problems with the underlying system that are separate and apart from whatever administrative policies and priorities are in place at any given moment. Truly fixing these issues that we're seeing at the border will not be possible unless and until both the executive branch and Congress work together to implement critical reforms. The United States needs a humanitarian protection system that is fair, transparent, and also expeditious. And that is something that we at the Council very much believe is possible. But we need Congress and the executive branch to work as co-equal partners to get us there. And in our recent report that my colleague Aaron described earlier in the program, we outlined a series of changes that Congress could pursue right now that we believe would make a significant change, that would make significant improvements to the current situation, that wouldn't require that we rewrite all of the underlying law, but also aren't primarily motivated by this desire, this obsession to make it so difficult to seek asylum in the US that people simply avoid doing so. The recommendations include things like increasing funding for humanitarian processing and to help expand access to asylum and ports of entry, creating a new emergency migration fund to help the federal government more effectively respond to increases in migration, expanding legal pathways for temporary workers, as well as for people that are here already with some form of humanitarian protection, among a number of other things. The ultimate goal, our ultimate goal, we believe, should be to create a system that both reduces irregular migration, but also reduces unjust outcomes. A system to create a system that more effectively meets the needs of both the US and asylum seekers. But what we're currently seeing from Congress is a much different approach. As early as tomorrow, the House of Representatives is poised to pass a bill called the Secure the Border Act of 2023 that is almost exclusively focused on making it more difficult to obtain asylum in the US by doing things like changing the legal standard that dictates those who qualify, and also making it so hard to endure the process that people give up or don't come to the US in the first place under this false assumption that that is actually possible given the historical moment that we're in. The bill would also, the bill would do things like restart the practice of detaining families with children, restart the construction of the border wall, require asylum seekers to be detained while awaiting decisions in their cases, send unaccompanied kids back to the countries from which they fled without assessing their protection needs, charging a fee for asylum, among many other things. This is not a good faith effort to fundamentally change the system and address the challenges that we're experiencing at the border, but instead an effort to continue to wield the issue as a political weapon in this moment and beyond. At this point, we do anticipate that the bill will pass the House of Representatives, but it does not have a path forward in the current Senate, thankfully. In the Senate, the most recent activity has come in the form of a bill from Senators Sinema and Tillis that would continue the status quo and force the extension of Title 42. We don't anticipate in this moment that that bill will go anywhere. And separately, Politico just reported that the Senate Judiciary Committee Chairman Dick Durbin is working with Senator Schumer on legislation to address border issues, although the details aren't yet publicly available. Certainly welcome news, though. What ultimately happens in Congress in the near term, if anything, will largely be dictated by how things play out at the border in the coming weeks. And it's something that we're monitoring very closely. There is, though, a very real opportunity to achieve something meaningful, given the attention that's being paid to the issue, the level of public awareness that there is about what is happening at the border, and the fact that the change is desperately needed. Getting there will require compromise. It will require time, it will require resources, but it is something that is possible if we're willing to set the politics and the distortions aside to help get us to a better place. Congress is supposed to be a co-equal partner here to the executive branch of the federal government, and our elected leaders, quite frankly, need to start acting like it. But I'll leave it there and hand it back to Angie so that we can get to your questions.
Thank you so much, Jorge. That was terrific. We have a lot of different questions, some that are very specific and some that are kind of broad. I'm going to start with a broad one just to kick us off, and then I'll urge my colleagues who are not answering live to try to do some of to type in the answers for the ones that they can. And so one broad question is that it sounds like on the one hand, we want to shut down immigration, but yet we seem to be opening it. So what are we to take from what the administration is doing, and what can we do as advocates and other interested citizens? Who wants to start with that one? Aaron, I'm looking at you.
That's a great question. I mean, I think what can we do as citizens here? I think this is a matter about holding the United States to the promises that we have made a long time ago to protect the vulnerable and to keep our arms open as a country to people who are fleeing persecution. For the last 43 years, we have had a right to seek asylum that is universal, that applies to all people, no matter how they enter the country. And this rule restricts that right. Unfortunately, that is probably going to require litigation to block. We know the ACLU has already indicated that they are going to sue. And so I think when we go forward from there, we're going to see litigation against this. But we also want to, people need to reach out to their members of Congress and argue that this is the wrong way to go about this. And so I think that's a large part of it. I don't know if other people would have other things they want to add to that.
I'll jump in. I think it's important to remember it's not just about whether people are able to come into the United States. It's about having a process to fairly assess whether people are fleeing persecution and need protection. The goal isn't to exclude as many people as possible. It is to come to fair and just outcomes with reasonable process. And so a change in our framing about how we think about the border and how we think about the people who are all coming here with their own stories, their own traumas, and their own backgrounds is really important.
Thank you, Alex. It sort of leads us to an observation about the paper that we put out. So Aaron, can I kick it back to you and just ask you to tease out a little bit about our recommendations, because I think it maybe gets at the heart of the question. We got
yeah. I have issues with the mute button today. Okay. So what I think is at the core of our recommendations paper, and we're going to put this in the chat and the link so that people can see a link to this paper, is the idea that it doesn't require a radical overhaul of U.S. immigration law to restore the humanitarian protection systems. It requires actually putting the resources into the system that we haven't done. And when we talk about this, we have to look at the history of the last decade of U.S. response to asylum seekers. And indeed, if you go back further than that. But in particular, over the last decade, we have seen administrations pour resources and funding into border enforcement alone, making very little investment into the humanitarian protection system. President Trump spent over $15 billion with a B on border wall alone. And some of that money came from the Department of Justice's counter-narcotics efforts. Others came from military readiness and infrastructure construction funds. But in total, he spent about $15 billion of US taxpayer money to build border wall. And it had no impact on asylum seekers, because the right to seek asylum applies to people regardless of, once they're on US soil or even if they're arriving in the country. So $15 billion is 17.5 times the annual budget of the immigration courts and 40 times the annual budget of USCIS's refugee and asylum divisions. That means that we could have had decades worth of funding for their court systems and the asylum adjudication systems that we instead spent on border enforcement, which did absolutely nothing to resolve the underlying issue. And today, we've ended up in a result with a dysfunctional system that serves the needs of no one, not the government, the border communities, or asylum seekers themselves. So what can the administration do? What can Congress do? First off, some of this the administration is already doing. They need to be surging more people to the border to process people safely and humanely. Earlier today, Secretary Mayorkas announced that they are sending thousands of processing coordinators and contractors down to help alleviate overcrowding, because I think the administration is very aware of what happened in 2019 when multiple children died in Border Patrol custody because the Trump administration was refusing to release people unless absolutely necessary. The Biden administration is authorizing the release of people to avoid this kind of overcrowding that led to the deaths in 2019. And so hopefully we aren't going to see those situations again. But those short-term solutions, but more contractors, more support, more processing, a lot of that takes time to put in place. And what the administration needs for there is resources from Congress to keep that in effect for the longer term. Because right now they're sort of robbing Peter to pay Paul, as it were. They're pulling resources from USCIS who are adjudicating asylum applications and other immigration benefits, and surging those asylum officers to the border, which means that they will be reducing the number of asylum officers that are processing affirmative asylum applications and pulling adjudicators who are dealing with things like citizenship applications or immigration visa benefits if they have previous experience working with asylum. So they're basically taking the legal immigration system resources and pouring them into asylum and border, which is something that Congress could fix. You know, if Congress actually funded USCIS better, you wouldn't have to do that. You'd have enough agents and officers to do that. We also think the government should be working better with receiving communities. And so we call in our report for the creation of a federal Center for Migrant Coordination that brought together DHS and state and local communities so that we wouldn't have the situation we have today where we have mayors and governors saying, where is the federal government here? Because from DHS's perspective, once a migrant leaves federal custody, then the federal government generally doesn't have much of a role to play after that point. The Center for Migrant Coordination could build DHS into a greater role of working cooperatively with communities at the border and beyond to ensure that that people have these opportunities. We also think that Congress could step in here as well. For example, transportation of migrants, things like that, coordinating where people who don't have somewhere to go can stay temporarily. If Congress funded the Center for Migrant Coordination, it could possibly create outreach offices in communities around the country that could make this a viable means of dealing with high levels of migration like we're seeing now. In addition, we call for more federal support for case management alternatives to detention. This is particularly important because for many migrants, figuring out how to navigate the asylum process is extraordinarily difficult, especially if they don't speak English and don't know anybody in the country. So there, having dedicated federal case managers, a little bit like social workers, could actually help people navigate the system and comply with their obligations without inadvertently missing a key aspect of this. In addition, we're calling for the administration construct non-custodial regional processing centers and to continue to increase legal immigration pathways and build up domestic and international refugee asylum processing capacity in Latin America. That latter one is particularly important because the US's refugee program has tended to focus on countries outside the Western Hemisphere, even though we are seeing such an increase in asylum seekers and refugees fleeing failed states in the Western Hemisphere. So we really need to build up that more close to home refugee processing system that doesn't exist at the levels it needs to today, that's really been focused on other parts of the world. But I want to end by saying that talking about our recommendations by emphasizing that a lot of this just has to be done by Congress. We haven't updated our legal immigration system since November of 1990. The first website went online in December of 1990. So our legal immigration system predates the World Wide Web. And we haven't updated our asylum system by and large, and the processing and the ways by which people go through it since 1996. So we are dealing, the thing I keep saying, and I've said this over and over again, because I think it just bears repeating, we're dealing with a 21st century migration and refugee displacement crisis with a 20th century system. It's 2023. It has now been 27 years since Congress has done any major changes to immigration, and it's really beyond past the time when Congress needs to step in. So I think that really emphasizes that this isn't going to be a challenge that's going to be solved by the administration alone. This is something that requires politicians to actually come together and have a good faith discussion about reforms to the system.
Thank you, Aaron. Folks, we're going to do our best to get to all of your questions, but they're numerous and they're kind of a little bit all over the place. Aaron, there were a couple about the refugee processing centers, and it's a recommendation of ours. But I think in terms of what the administration has announced, do we have any kind of details or a few questions on that?
Yeah, so the regional processing centers, I saw a number of questions about those. So really briefly, we know that the administration has said they're going to open the first 2 of them in Guatemala and Colombia, and that they potentially plan to open more. These locations are potentially places where they would be able to screen people for refugee status. Not asylum. Crucially, in order to win asylum, you have to be in the United States. So you couldn't apply for asylum at a regional processing center. That's just not how asylum works. We think that these would be open to migrants from outside of those countries, especially in Guatemala, with migrants who are coming through Central America all have to go through Guatemala to get to the border. So we think this would be eligible, any national who was a migrant who could go to those places and find out whether they were eligible for some form of status. This is particularly important, for example, for the humanitarian parole programs, which you are not eligible for if you cross Mexico's border from Guatemala into Mexico without lawful status. So they're trying to say basically, look, if you've gotten to the Mexican border, if you cross, you're not going to be eligible for parole. But if you stay in Guatemala and go to one of these regional processing centers, maybe you will be eligible. So I think that is part of the goal of it. But again, we just don't have that many details about these yet. We're going to be keeping a close eye on them. And when we find out more, we will, of course, be sharing with the council audience.
Thanks so much, Aaron. We've gotten a lot of questions about the new rule. Does the new rule presume that one is eligible or not eligible for asylum if they were denied in Mexico prior to applying in the US? In other words, should Mexico expect a dramatic rise or fall in asylum claims? And we know that Mexico's asylum system is very young and not particularly robust yet. So why don't we talk a little bit then about what is the expectation of a person? Should they have gone back to Mexico to apply for asylum? What do we know about what the rule does there?
I can jump in there, Angie. The rule does indicate that if you do not seek asylum in a transit country or use CBP-1 to access the asylum process, there will be a rebuttable presumption that you do not qualify for asylum. So one of the ways that migrants could qualify for asylum in the United States is to first seek asylum in transit. It's impossible to suggest that anyone do that without knowing their personal circumstances. And we don't pretend that we would be able to. What we do know that though is that a lot of the transit countries do not have robust asylum or protection infrastructure. And also if you apply for and are granted asylum in a third country, you will no longer qualify for asylum in the United States. The rule today did clarify that if you apply for asylum and are denied asylum in a third country, you could still qualify for asylum in the United States, but that you cannot be denied asylum based on abdicating or leaving behind or abandoning your asylum process in another country. So migrants are going to face a really difficult conundrum, whether it is safer and a better idea to seek asylum in a third country through a process that may not be meaningful and in a place where they may not be safe. There's demonstrated evidence that certain types of migrants face particular harms in transit to the United States, in particular Black, Indigenous, and LGBTQ migrants who could, in theory, be kind of cornered into applying for asylum in transit, even though it might not be a good solution for them.
Thanks very much, Alex. I'm going to go to another one to Capitol Hill. So looking at you, Jorge, one of the questions is, what are the prospects for Senator Menendez's recommendation? The senator from New Jersey issued his border plan a few weeks ago. So maybe you could just give folks a little bit of a sense of that and what you think the prospects are.
Sure. So Senator Menendez came out and announced he unveiled a series of proposals to try to improve things at the border. And it's fundamentally, I would say it's good to see a member of Congress, a powerful member of the Senate, come out to sort of stake their claim and make a case for changes that that could very well improve the situation at the southern border, but that don't require that we embrace really harsh and draconian policies that do things like, you know, significantly increase detention, force us to detain families. We don't necessarily agree with everything that was in that proposal, but it's a different perspective from a notable, powerful person on Capitol Hill who has an important voice and a unique perspective that is great to have out there, so that we're not stuck in the situation where only the extremists are talking about these issues. So what they will ultimately translate to is still to be seen. I mentioned earlier that Senator Durbin is working with Senator Schumer on a new proposal. It's possible that it could include something along these lines. It's hard to imagine that any negotiations happen in the Senate on immigration issues that do not include recommendations and the voice of Senator Menendez. So that was a long way of saying that there is a good place for those recommendations. We're glad that they were published. What they ultimately translate to is still to be seen, and we should frankly know more, I would say, in the next couple of weeks.
Well said. Thank you, Jorge. Alex, I'm going to kick one to you. What is the fastest, most effective way for attorneys, particularly those in border states like Texas, to help individuals seeking protection?
Absolutely. I'll go ahead and drop a link in the chat for our volunteer form. We do coordinate pro bono legal services for migrants in detention and in removal proceedings, but there will also be incredible need among legal service providers at the border who are rapidly trying to assess the circumstances, better understand the practical implications of the asylum transit ban and the CFI screenings that are happening in CBP custody, and to seek the support of pro bono attorneys, interpreters, and other professionals in doing this work.
Excellent. There are a couple questions, and Aaron, you may be typing this, I'm sorry, about whether the restrictions apply only at the southern border, or do they apply at the northern border, other parts of the country? Do we have a sense of the
Yeah, I was actually literally just typing an answer to
so
that.
sorry. I realized that
Yeah.
after I started talking.
And I realized, I think I may have misspoken earlier when I said this applied only to people across the southern border. If I said that, that was what the proposed rule said. We found out this morning that they've expanded it to any people who cross either the southern border or the coastal borders. So that means that Cubans and Haitians, for example, who are arriving via a coastal border, or as we see in the past, sometimes people in San Diego who take a boat to get around the border there, this rule would still apply to them.
Great, thank you. There are also a couple of questions one is about family detention and whether we're going to see a return and increase in family detention. What do we know about that? And then related, the status of unaccompanied children. You know, there was a big, large numbers came early in the administration, but now we're not really hearing very much about that. And do we know, are the numbers still large of unaccompanied children, and are they still getting shelter and ORR services?
I'll hop in on the question of family detention. So the administration has indicated so far that they are not going to bring back family detention. That is a really crucial key shift, because there was a lot of talk a few weeks ago that they might be considering bringing it back. So far they've indicated that that isn't going to happen. But of course, the administration could change this. And for example, Jorge mentioned the House GOP's border bill that is going to be voted on this week actually orders them to detain families. So we could see Congress acting to force the administration to bring back family detention. On unaccompanied children, yes, unaccompanied children do continue to cross the border and continue to be placed into federal shelters. That is not changed by this rule. They are still, under this rule, they still go straight to immigration court proceedings and do not go through the credible fear process if they are from countries other than Mexico or Canada. So unaccompanied children are not directly impacted by this rule as such, and family detention is still so far not coming back.
Got it. Thank you. There's a question about the rebuttable presumption in the rule and whether it, my understanding of the rebuttable presumption of ineligibility to apply for asylum, it cannot be appealed to an immigration judge as part of the CFI process. Is that right? So can you appeal that? Do we know?
So I believe there's some nuance here. If you first are denied your credible fear and are then subjected to a reasonable fear screening, and that is denied, you are able to request for that denial to be reviewed by an immigration judge. It is technically not an appeal, but there is a mechanism for immigration judge review.
Good. We have another question that I think is sort of a broader picture one. So let me see if I can try to summarize it. There are still a vast number of migrants who, because of life circumstances, will always be seeking to access the US because of failed societies. We have a crucial need for labor in the US, landscapers, restaurant, hospitality, etc. And the US that currently forces US employers and foreign labor to break the law with no ability whatsoever to address through legal pathways their need for labor. What is our view on a new policy to address this disconnect so that we can marry up humanitarian immigration and employment-based immigration and actually meet the needs of employers? What do folks think? Okay, well, I'll take a crack at it. I mean, as I think, Aaron, you indicated, I don't even know if fax machines were around the last time that we updated immigration laws. And so we have a frankly static number of employment-based visas that are available every year. And when you think about the dynamism of this economy, that makes absolutely no sense. So yes, of course, we need to be able to bring in particularly needed workers, as we're seeing our unemployment rates, I think, well below 4% at this point. And at the same time, meet the humanitarian goals that we have as a nation, like a character of wanting to protect people and be able to manage our border. Like these are all kind of common sense principles. And unfortunately, our need to update our immigration laws has been hijacked and has become the most politicized issue, or at least certainly one of the top few in the debate today. So I think putting forward those stories that we all see every day of people who have come to this country, have been successful, employers that need workers, I mean, that's the way to change the conversation, is to begin to put just like a different face on the issue and to take that to policymakers. I mean, as Jorge said, it's refreshing to see that Senator Menendez came forward with a plan, but it shouldn't be just like one Democrat from New Jersey. That should be something that the Democratic caucus comes forward with a plan. Sorry, allergies and losing my voice. So we, urge people to weigh in with your lawmakers as well. All right, next question. So we have a question about funding and how to fund some of the proposals, since CBP and ICE already receive massive amounts of funding, more than any other federal law enforcement agency. Many of us have been working to reduce this funding that ultimately harms migrants as well as people already in the US. Would advocacy around your recommendations suggest increasing ICE and CBP budgets, or is it about a redistribution of resources that they already have?
Yeah, that's a great question, because at the American Immigration Council, we have generally opposed new funding for immigration enforcement. And I think it's very important to note, we do call for more funding, but we want that funding to be heavily restricted specifically to humanitarian processing and adjudication. So no new funding for ICE detention, no new funding for Border Patrol agents, but yes on funding for Border Patrol processing coordinators who carry out the duties of who do things like transportation and welfare checks and processing paperwork and making sure that the agency is coordinating between like local groups, things that are not enforcement, that are humanitarian processing. This is a difficult question. Can these agencies be trusted with the funding? And we've seen in the past that at times they can't be. In 2019, when Congress gave the Border Patrol funding for responding to humanitarian issues, and what they did in some agencies, some Border Patrol sectors spent that money on ATVs and HVAC repairs. And so there is a key crucial role for oversight and accountability provisions built into this funding that we suggest in the report, because we acknowledge that the agencies have misused spending and funding that has been given them in the past. So to the extent that we are suggesting that enforcement agencies, that CBP get more money, we are tying that very carefully to oversight and restrictions so that this money can't be transferred over for enforcement related purposes. But at the end of the day, I think as an organization, we generally think that if we are going to do the transformation of the humanitarian processing system that we want, that just is going to require more money. And in doing so, that money should not come in the form of a blank check. It shouldn't come in simply just one or two lines in the budget bill that says, 500 million for humanitarian processing, and then the agency can really define what that means. We think it's going to have to be very carefully crafted language that ensures that there is oversight. And so, for example, you'll see we often suggest that any additional funding come with mandatory review by the Office of Inspector General or the Government Accountability Office to make sure that there are watchdogs keeping track to make sure the agency does not misuse this funding for things that we don't think would fit this purpose.
Thank you, Aaron. Alex, did you have a question that you were going to answer?
Yeah, we received a question about, the fact that in this new rule, the government is pointing out and referring to asylum and whether the rule distinguishes between asylum, withholding of removal, and protections under the Convention Against Torture. The baseline answer is yes. The government is attempting to adhere to its non-refoulement obligations by permitting individuals to receive reasonable fear screenings if they are denied their credible fear screenings. This means that asylum seekers would be held to this higher reasonable fear standard in order to be able to enter the United States and to seek protection. It's important to remember for those of you who may not have more background that withholding of removal and protections under the Convention Against Torture are inferior remedies to asylum. Asylum is a durable protection with a pathway to citizenship. With withholding of removal and protections under the Convention Against Torture, you cannot be expelled to a country where you have a well-founded fear of persecution or where you could be tortured, but you do not have long-term status in the United States. And if you leave, you lose your protection.
All right, folks, we have answered nearly 60 questions, and I know there are more in the queue, but I'm afraid that we're going to have to wrap up. I take it by the appetite, the people who registered for this and the questions that we're getting, that we should probably do another webinar in the very near future. Given the breadth of our paper, 13 recommendations, each of them, frankly, could be their own paper. The idea is that over time, we will have a series that will look into each of these different recommendations and dig deeper, and we'll juxtapose what we're proposing as solutions next to what we're seeing happen as the situation on the border unfolds. So we'll be coming back to you, but thank you very much. This concludes the webinar.